Good evening, everyone. Welcome to our tonight's webinar brought to you by SCORE, North Chicago. Presenter is Larry Zanger, mentor with the North Cook and Lake Counties chapter of SCORE. And my name is John Fisher. I'm one of the 65 mentors that we have with our SCORE chapter. I'm going to be the moderator for today. And as a reminder, this session is being recorded and it's going to be made available later on our YouTube channel. And you can get to the YouTube channel by going to our website, northchicago.score.org, and click on the YouTube icon that appears along with Facebook and the other types of icons here. So please submit your questions using the Q&A function here, which should be down at the bottom of your screen. And we're going to address those questions after Larry has given his presentation here. So Larry, if you'll move on to the next slide, I'll cover that. So SCORE is a nonprofit organization that's been helping small businesses since 1964. We've got over 10,000 volunteers in 300 different chapters across the country. So yes, then we have free confidential mentoring for small businesses. We've got a really large library of resources for those who want to start a business or grow an existing business. And to request a mentor, just go to our website at northchicago.score.org here. Let's see, someone wants me to turn on the Zoom live transcript, and I believe I can do that. So hopefully that has taken place here. So Larry Zanger is a member of the North Chicago or North Cook and Lake Counties chapter of SCORE, and he is an attorney with decades of experience advising businesses on formation, growth, and sale of their companies. And he's also got a lot of experience in all types of transactions involving information technology. So he's a frequent speaker and writer on various legal and business topics. And he was also on the faculty at the University of Illinois in Chicago and taught courses at the Benedictine University, DeVry University, and Illinois Institute of Continuing Legal Education. So Larry's listed in the Who's Who in America, Who's Who in American Law, and Illinois Leading Lawyers. So he's been there since 2006. And he's been selected by the best lawyers in America as one of the nation's leading information technology lawyers. So he's also a certified public accountant, and he won the Elijah Watt Sells Award for his performance on the CPA exam. He is serves as chair of the Chicago Bar Association, Cybersecurity and Data Privacy Committee. So Larry, you can start your presentation now. I will come back afterwards with questions from our audience, but feel free to start the presentation.
Thanks, John. Just on behalf of SCORE and on behalf of me as a retired lawyer who's no longer licensed to practice, I wanted to make sure everybody understood that nothing in this webinar is intended to or does constitute legal advice. Everything in the webinar are for general informational purposes only. So starting off with types of intellectual property, it's important to know that intellectual property frequently constitutes the most valuable asset of any business. Intellectual property is constituted of copyrights, which is the protection of what are called works of authorship. We'll talk about that in more detail in a few minutes. Together with patents, copyrights were created by the Constitution in Article 1, Section 8. There's a so-called patent and copyright clause. Trademarks, which deal with the identification of goods and services in the marketplace, were created by the Federal Lanham Act that was passed in 1946. Patents deal with the protection of an invention or design. It's rare for a small business to have one, so I'm going to touch on patent and patent protection only lightly when we get to that section. The fourth type of intellectual property is the area of trade secrets. Trade secrets is designed to protect confidential information, and it's created by statutes, and the protection that is granted is not government protection as with the other three, but the protection is by the behavior of the person whose trade secret it is. Copyrights cover original works of authorship. These include, and works, they're called works, copyright, things that are copyrighted are always called works. There are literary works, which has been deemed to include software. It includes non-dramatic textual works. So it doesn't include things like plays, dramas, and screenplays, which are in a different category. And it includes these works whether they do or don't have illustrations. Then there are musical works, which include accompanying words. So you're talking here about musical scores. Dramatic works, including any accompanying music, include plays and dramas, screenplays and scripts. Then there are pantomime and choreographic works. There are pictorial, graphic, and sculptural works, which are more like works of art. Then there are motion pictures and other audiovisual works. Then there are sound recordings, which is different than the second category of musical works. Sound recordings are a separately copyrightable class of works. And it is the movement of a musical work to some kind of sound recording. Formerly, it would have been on tape or on wax recordings. Now it's mostly on digitally and on CDs. And the last is architectural works. It's important to understand that copyrights do not extend to ideas or procedures. Those are, if protected at all, those would be protected by patents. With respect to copyrights, regardless of the category, to qualify for copyright protection, a work must satisfy these two fundamental criteria. The first is originality, which means it has to be produced by the author's own intellectual efforts, not copied. It doesn't have to be novel, but it does have to represent a considerable amount of creative effort. And understand that the whole area of copyrights and patents is to protect creative effort. The second thing that a copyrighted work needs to have is fixation in a tangible form. So this means that the work must be applied to some tangible medium like paper or a canvas or the internet or a CD or a DVD or a film or a microchip or something of that nature. Copyright law designates that only the holder of a copyright in a work may make copies of the work. So that includes publishing it. Only the copyright holder may distribute the work. That means to sell or license it. Licensing a work means that you are granting someone in writing a limited use to the access to the work and the use of the work. And that is different than selling it to them, which means they have all rights to do whatever they want with the work. The holder of the copyright is the only one who may make derivative works. which are things like translations to another language or an abridgment, like a condensed work. And finally, only the holder of a copyright may share or perform the work in public. Now, all of the rights that a copyright holder owns may be licensed to someone for their use, so that the copyright holder doesn't need to be the actual person sharing or performing the work, or publishing the work by running a printing press. These rights can be granted to others by assignment through a license. Together with copyright, there is a situation known as the work for hire doctrine. And the reason I'm covering it here is that it's an area where the result of the relationship between the author of the work and the person who paid for the work is counterintuitive. Work for hire situations arise in these following circumstances. First, a copyright, according to law, is initially owned by the author or authors of the work. The only exception for that is in the case of a work for hire. And a work for hire can arise in these two situations. The first is where an employee creates, within the scope of his or her employment, a work, and in that case, the copyright is owned by the employer, who is the common law employer of the person who created the work. The other circumstance where a work for hire occurs is where two parties enter into a written agreement designating the creation of something that they call a work for hire. And this is the most important part, and that work which is being created falls within one of 9 specific categories of work designated by the Copyright Act. These include a contribution to a collective work, a part of a motion picture or other audiovisual work, a translation, a supplementary work, a compilation, an instructional text, a test, or the answer material to a text, or an atlas. Now, you notice that this is a very, very limited number of circumstances in which a written agreement for a work for hire can actually create a work for hire such that the party who's paying for the work being created owns it. If the work does not fit into one of these specified categories, it will not be a work for hire, even if the parties in their agreement designate it as one. And in that case, the author or authors, independent contractors to the hiring party, retain the copyright, and transfer must be accomplished through a written assignment of copyright. I have taught copyright and intellectual property at colleges and universities as a guest lecturer in their certification for information technology officers and things like that. You'd be amazed how many people don't understand that when they hire an outside third party to create something for them, they have to be very careful about the written agreement under which it is created. Otherwise, they will not wind up owning what they're paying for, which is a copyrighted work. Next, we'll talk about registering a copyright. A copyright exists from the moment that a work is created and fixed. There is no obligation to register the copyright with the United States government. That is, the Copyright Office of the Library of Congress is where copyrights are registered. There is no requirement that you do that. Your copyright exists, and if you put a copyright designation on your work, it has copyright. And now, even if you don't put the copyright designation on, it is copyrighted. It is considered to be copyrighted. However, obtaining a federal copyright is required to be able to access federal court. And that's where you go if you want to be granted an injunction against infringement and to be awarded damages for an infringement. Now, a lot of people don't record a copyright for something they create because one of the obligations of filing a copyright is to include what's called a deposit copy of the work being registered. Now, if you're talking about a book, that's not a big deal. But if you're talking about a piece of software, it is a big deal. And when I get to the end of the next section, I'll talk about what you can do to protect yourself in that circumstance. Copyright registration is relatively painless. It costs as little as $35, and the process is reasonably straightforward. You go to the office, the copyright office, and all of the explanations are there. As I said before, the copyright must be accompanied by a deposit copy of the work that's being registered. And there are provisions in the Copyright Act and regulations that permit the marking out or obfuscation of parts of any copyright deposit that is considered by the copyright, the applicant for the copyright, to be trade secret or confidential information. So in the area of software, that would mean that you could black out certain parts of the code that you have to deposit if you believe those are the secret sauce of your product. The next area is trademarks. Trademarks are intended to permit consumers to identify the source of goods and services in the marketplace. So understand that it is consumer focused, and if there is an infringement argument between two people who have similar trademarks, the court will look at surveys of consumers as to whether or not they were misled by the competing copyrights in the ownership, which company actually owned those products in the marketplace. So there are also, it should be noted, there are 45 distinct classifications of trademark goods and services, which are available for review at the Trademark Office online at the United States Patent and Trademark Office site online. The important piece about that is that when you apply for a trademark, you're not applying for a trademark in the entire universe of ways it could be used. You're applying for it in connection with the distinct classification of goods and services that you believe your goods and services occupy. So you can have multiple companies with the same name occupying different products and service categories. So you can have United Fruit and United Airlines, all with, both with trademarks for the name United. So a trademark protects a word, a name, a phrase, a design, a sound, or a smell, or any combination of the six that is used to identify the source of goods or services in the marketplace. You have to remember that a trademark does not exist alone. It is not something you can obtain just because you have a name. It has to be connected with a good or service and apply only to the product classes for which you apply and in which you believe your product or service exists. Examples of trademarks are the word Nike, the word McDonald's, the Apple word, the logos that accompany each. Also phrases like fly the friendly skies or just do it. And in fact, the sound of a Harley-Davidson motorcycle was actually trademarked by one of my former partners when he worked in the intellectual property department of Harley-Davidson. So there are many non-traditional forms of trademark, and those go mostly to designs, sounds, and smells. How do you go about obtaining trademark rights? Well, the first thing you have to do is use the trademark in commerce. The United States rule, unlike the rule in many other countries where it is by registration, the United States rule is that the first to use a trademark in commerce is the owner of that mark. Use in the trademark world means that the trademark has been employed in connection with the sale of the goods or services in the marketplace. The term use in commerce means that the bona fide use of a mark was done in the ordinary course of business, that you didn't have a sham transaction. You didn't just sell one copy of something or one piece of something to your brother-in-law. You have to be in the marketplace, and it has to be used in commerce. And then you claim that use as the date of first use, and that is when your trademark rights begin. Registration is done with the United States Patent and Trademark Office, which is called the USPTO. It covers, they have people in the Patent and Trademark Office that cover both patents and trademarks. There are different branches, there are different examiners, but that's the place where you do your filing. You don't have to register to file in order to own rights and trademark. However, for most companies who sell online, it's important that they realize that federal registration, that is registration that protects them in more than one state, is only obtainable by registration with the United States Patent and Trademark Office. And in addition, just like with copyrights, that registration is required to be able to access courts, to obtain damages for trademark infringement, and to obtain an injunction to cut off further infringement. There are symbols that are used with trademarks. The uppercase TM is a symbol that is used to denote a mark being used without registering with the PTO. It is also used by people who want to let others know that they have a mark in process, but you don't get the circle R symbol until you have a federally registered trademark. And that comes when you have gone through the lengthy and often excruciatingly long trademark review by trademark examiners that will fight with you about what categories you're in, will fight with you about your description of the product being trademarked and in connection with a name, and that can take as much as 18 months. So often people will seek to do trademark searches in advance of filing the trademark so that they have some sense of whether or not the trademark will be registerable, so that they don't spend the first 18 months while the process is going through wasting time and money related to a mark that they can't ever get. It's for that reason that people use intellectual property lawyers who are experienced in reviewing filed trademarks. You can also, that service is also available at a lesser charge than most lawyers charge if you go to an online service like Rocket Law or some of the others. Now, it's also important to know that not all trademarks are created equal. And the ones that you should consider dealing with for your own intellectual property investment are ones that are called strong or distinctive. And they're called that because they provide enough protection for the owner of the mark to prevent third parties from using the mark. In reviewing trademarks, the trademark examiners look at 5 categories of marks that run from the weakest to the strongest. A generic mark, which gives you basically no protection at all and will be completely set aside by a trademark examiner, is a generic mark is one that uses common terms to name the products or services. For example, if you wanted to call a brand of shoes just shoes, you know, that's unregisterable. If you were to use something together with shoes, then the something would be looked at in connection with whether it was trademarkable, and the shoes part of it would have to be what they call disclaimed, so that you would not be able to use you know, a trademarked shoe. You could just use the trademark in connection with shoes. The second category is what is called descriptive. It's another category that does not get you very good protection until you've used the mark in the marketplace for a fairly long time. And what a descriptive trademark is one whose dictionary definition is synonymous with the quality of a good or service. So a mark for cold and creamy for ice cream, for example. When you get to suggestive marks, arbitrary marks, and fanciful marks, you're now getting to marks on which you can probably get trademark protection. A suggestive mark is one which suggests a characteristic or quality of goods and services, but it doesn't state the nature of the goods and services. So the following trademarks in the area of technology are suggestive in nature. So Microsoft for microcomputer software and Android for artificial intelligence user interactive software are trademarks that don't outright specify that they relate to computer or technology, but the names themselves with imagination can have an association. So that's a suggestive mark. The arbitrary mark is a very, very strong and distinctive mark. An arbitrary mark is a name that in no way refers or has any suggestion toward what is being trademarked. So the Apple name in connection with computers and smartphones has absolutely no relationship to computers and smartphones, except by their being in the marketplace and manufactured and sold by a company called Apple. A fanciful mark is a mark that has no meaning whatsoever other than as a trademark. It's an invented name and it represents nothing other than the company or the product. And examples of fanciful marks include names like Xerox and Exxon, and actually the names of most drugs that you'll see on TV. Those are made up names. Okay, so why do you protect your trademark? People talk about trademark protection. Well, the first reason you protect your trademark is that the very process of protection forces you to do a search such that you avoid infringing somebody else's trademark, which will result in your being sued, and that's never pleasant. As long as a trademark is being used by a trademark holder, the trademark rights never expire. Although federal trademark registrations, the registration expires, they can be renewed every 10 years, so long as the trademark rights are used continually and have been enforced. And you'd get a notification from the trademark office about a year before the renewal date, and you'd be required to file a renewal affidavit that the mark has been used continuously since the last renewal, and then give them copies of ways in which the mark has been used in connection with your product in the product class. Another reason to protect your trademark is that it's an easy way for customers to find your business and the goods and services that you offer. It's also an effective way to communicate to your customers about what your business does and what goods and services are offered. And finally, trademarks can be used over time in connection with all your branding efforts and serve as a great way to grow a business through online and offline efforts. Trademarks, it's usually trademarks and copyrights and patent value that gives you the significant assets of most businesses. In order to protect your trademark, you're obligated to police the mark. And to police the mark, you have to check the marketplace to be sure that your trademark is not being used by others or being infringed by others. Because if you don't do that, you are devaluing your rights. And the must word that I have in the first sentence is not a throwaway imperative. It is important. If a mark is not policed, then you as the holder risk losing the right to the trademark. Your exclusive right to use will be diluted and could ultimately be lost. So how do you go about protecting and policing and monitoring? The easiest way to do it is to use Google Alerts and other search engines to check for infringements. Apart from this, you can hire a trademark watch service. And what those services do is dig into various trademark registries to find copycats. They check advertising, they check online activity, they check all different kinds of things. If you have the money, hiring a trademark watch service is worth it, because most people don't have the time or employees available to check the world for an unauthorized use. You must be vigilant in stopping infringements, that is the use of your trademark by another. Otherwise, the court might presume that you're not bothered by the use. So somebody, if you continually allow trademark infringements, you dilute your rights. And when you go to court to protect your rights against somebody's use, they will cite against you all the different people who are using your mark against whom you took no action. And the more steps you take to protect your right, the stronger your position to argue that your trademark is important to you and that you value it enough to take proactive steps in protecting them. All right, now we're going to move on to patents. I'm just going to say a couple of slides about this just to explain what they are and how you go about protecting them. A patent is a statutory right that you are granted by the United States government that permits you to offer, sale, and precludes others from doing that with regard to an invention or design within a limited territorial scope. And a patent issued by the United States Patent Office is the United States. If a patent is granted by the USPTO, the patent owner has the right to make, sell, manufacture, and import the claimed invention or design. This essentially gives you, as the patent owner, a limited monopoly. That is, no one can do anything with your patented design or product for 20 years from the date of the first application if it's an invention patent, and 14 years if it's a design patent. So either an invention or a design can be patented, and those were the periods of time that each is protected. It takes an average of about 25 months for a patent to be processed, so that lessens the amount of time that you can benefit from your patent if you wait for the patent to be issued before you start using it. When people think about patents, they tend to think about preventing inventions like electric cars and solar panels and pharmaceuticals. These would be covered by utility patents, but a patent can also protect designs as well. At an earlier time in the software world, the Patent Office was authorizing patents of software. They got into a little trouble doing that because the patents that they were offering were too broadly written. And because of that, patents were granted to processes that tended to blot out a lot of software products that were in the marketplace. This has been revised, and software patents are extremely hard to get now, but it doesn't stop people who hold software patents from trying to exclude others from the marketplace. Finally, about patents, I'm sorry, not finally, but it is important to know that unlike with copyrights, an employee generally retains ownership and patent rights of whatever he invents during the course of his employment. So if you're in a business that has patents and has patentable material, and you have people that are working for you that are working on creating those patents, it's important to know that you have to have a written agreement between them and you assigning ownership of the patent to you. To protect employees against what was considered to be a bargaining power disparity with respect to such agreements, Illinois and several other states enacted what is called an Employee Patent Act. The Illinois version of it can be found in the Illinois statutes with the site that's in the slide. And these Illinois Patent Acts restrict the types of inventions an employer can require an employee to contractually assign. Essentially, ones that the employee does on his own time with his own equipment and not during the employer's time with the employer's equipment, and which do not relate to the employer's business, can be kept by the employee. Finally, it's important to know that patent rights do not exist outside the federal registration system. So there's no right that springs from the creation of something that would be patentable like it does with copyright. And there's nothing that, that exists with respect to trademarks. In a patent system, there's nothing that's similar to trademarks in that you can have it for a while and then you can, file and you get it and it relates back to your first date of use. The patent system follows the first to file principle, which means that the first party to file for a patent for a particular invention or design will own superior rights to that, to the patent, superior rights. That's different from the trademark rights, which are earned by first use. It's important to note that patent filings are enormously complex. They're enormously technical, and they're unbelievably expensive. And so to be certain that these are done correctly, hiring a patent attorney is highly recommended. The thing that makes patent filing so complex is that they require technical drawings about the thing that you're trying to patent. They are expensive because before you file a patent, you have to check all the existing patents on inventions that are similar to yours to be sure that you are not infringing them, and that you've done what is called advanced the art, which is a technical term in patent law, which means that you have done something to bring something new to the area in which the patent applies. The fourth type of intellectual property that I listed on the first slide is something called trade secrets. Trade secrets do not receive any protection from a government filing. There is no government filing. Trade secrets are protected exclusively by the behavior of the owner, and what he has to do is described in state statutes. Examples of trade secrets are things like customer lists, proprietary pricing formulas, unique algorithms, manufacturing know-how, computer source code, architectural plans and designs, and items like the Coca-Cola secret recipe. Trade secret law protects against third parties stealing or otherwise misappropriating confidential information, such that which confidential information gives the owner a business advantage over those who do not know such information. It's different than what people consider to be confidential information. It's like a higher level of secret than just plain confidential information. So trade secrets, as I said, are protected by the action of the owner. And this action means that he keeps it confidential. This includes taking reasonable steps to prevent any unauthorized disclosure of the trade secret outside his business. This is done by using contracts, employee policies, physical security measures, and non-disclosure agreements, what are called NDAs. Courts have repeatedly reiterated that the use of physical security measures and NDAs constitute the most important way to maintain the confidentiality of trade secrets. It's also important to know that they need to be restricted to people who have a need to know, and that any important materials are stamped as trade secret or confidential and are held under lock and key. If you have things that you consider to be trade secrets sitting in a ring binder on an open shelf in somebody's office, that you're in trouble. If access to a trade secret is not strictly controlled and a third party gains access to it and uses it, the third party may successfully argue that the formula, pattern, device, or compilation of information is not entitled to any trade secret protection. Then the information is in the public domain and free to be used by anyone. And whatever it is that you thought you had, you no longer have, and it's out in the world. So it's important, if you have trade secrets, to understand what you need to do to protect them. As I said, trade secrets are created by statute. In this circumstance, there's something called the Uniform Trade Secret Act that was created by a governing body of uniform laws in the United States. They gather information on what should be included in these uniform acts, and then they disseminate it to all of the states. The states use it as a basis for their own determination, but it doesn't have to be exactly word for word what the Uniform Act says. So the Uniform Trade Secret Act, which was created in 79 and was amended in 1985, currently has 48 states that have adopted it more or less in its entirety. And also the District of Columbia, the Commonwealth of Puerto Rico, and the U.S. Virgin Islands have adopted the UTSA as the basis for their trade secret law. The only two states that haven't done so are New York and North Carolina. And the North Carolina trade secret statute, though it is not essentially the US UTSA, it borrows significantly from it. So that is the end of my materials. I hope you got something out of all of this hodgepodge of information. It's a very complicated area. There's a lot of material available on the score.org website in the library that elucidates different kinds of intellectual property further. And that's it for me.
Hey, thanks, Larry. This has been really interesting. A lot of you've covered a lot of detailed information in a way that is understandable. So that's great. And we have a bunch of questions here. So I'll try to combine them if I can, but
sure.
The first one here is that it's from as an independent consultant, their intellectual property are the handouts they use for training.
Okay.
So I signed a contract stating that they can't use my slides for anything else besides the training.
Right.
But the attendees are not familiar with the wording in my contracts. So I copyright the handouts. However, how can I prevent people from stealing my IP and use it in the future for other training sessions?
Yeah,
would specific wording in the contract help? And then a second question was, could you expand this to like online webinars and certifications, licensing, that kind of stuff?
Yeah, I mean, protect in the world of the internet and in the world of zeros and ones constituting, things that you're trying to protect. It's much more difficult than ever before. Certainly, if you have copyright designations on your materials and you've filed them in the Copyright Office so that you can go to sue somebody, that at least gives you a cudgel. But there really is no way to stop somebody from taking a handout that you have permitted them to have in connection with a contracted set of services that you've done for their employer. I mean, if you did, the only way you could protect it is to take them back. I mean, you can't, there's really no way to track what people are doing with them. Now, you could certainly have a disclaimer on the handout that says this is the copyrighted property of XYZ company, and these materials are being given to you solely for use in connection with this seminar or webinar or whatever it is. and any other use that you would make of them is illegal and subject to federal lawsuit, which is what a copyright infringement case is. I don't know if that went far enough.
Well, sometimes it's a matter of who has more money to spend.
That's absolutely the case. Sure.
I've had experience with people who are companies who have actually literally stolen software products from people, but the company that they stole it from didn't have enough money to go against the bigger company in terms of number of lawyers and all of that stuff. So
it happens.
Unfortunately, it's that kind of thing happens. So a couple of maybe short questions here. One is they've got multiple artworks that need to copyright before selling them. How many items can you submit for the $35, or is that per item?
Per item. So it would be per work.
Okay.
So if you have,
related
and then what you'd have to do is you wouldn't, the deposit wouldn't be your picture. The deposit would be, a JPEG file or something like that, because everything is filed with the Copyright Office is filed online. So they prefer things to be digital filings.
So here's a related question about music. Would I send the music on paper and or the full recording of the song in terms of copyrighting music?
Well, if you send a recording, then you're copywriting a recording, which is a separate copyright application and fee. If what you're doing is copywriting music and words, you could copyright. You could send in the sheet music.
Okay.
And you could send in a digital copy of the words.
Yeah. So it's interesting. So in terms of music, if you're sending that in, that's a particular performance of that music.
Exactly.
As opposed to the music itself.
Exactly. So a sound recording.
So we want to be careful what you copyright.
Exactly. A sound recording is a separate copyrighted work, and actually, in order to be able to copyright it, you need to get a clearance. You need to get permission from the person who created the work, because when they created the work, they got the publishing rights, and creating a sound recording is a publication of that music.
Interesting. So here's a question on someone has a concept that they're presenting for funding with Verizon, and it's also eligible for several U.S. Economic Development Agency places for funding. Do I need to get an NDA before I share that with them?
Yes. You also should. If it is a concept that is susceptible of copyright, I would also copyright it, so that you can prove the date that that when you gave it to him, it was all. This is what it contained. It's very and the problem with lots of these large companies, when you're trying to present a concept or an idea to them, is they have tens of thousands of people all over the world sitting in front of computer screens trying to create something. And it's almost impossible for them to agree to a non-disclosure, because they can't know what somebody in a lab in Romania is doing and whether they've already created what you're trying to sell them. That's just factual. It's not.
Yeah. So So again, that that you have to be careful on those things, but
exactly.
Certainly asking for a non-disclosure agreement is something that you can do.
Absolutely can do, but don't be surprised if they say no for the reason I just put.
Yeah. So here's a couple questions on the work for hire concept here. Okay. So if you pay somebody for a logo, does the creator own the trademark of the logo?
No, the creator owns the artwork.
Is that a work for hire?
The creator would own the artwork.
And because it's not one of those 9 categories that I discussed earlier, you should get, you have to, in your work for hire agreement, you have to have them agree that you own the copyright in that logo because it's art, and it is a creative work of the person who created it, the digital artist or the commercial artist or whatever. and then you own it, and you can do whatever the hell you want with it. But yeah, you don't own it if you don't own it if you don't own it. And it's, so you have to be very careful what your agreement says, and it has to be in writing because it's about the title to intellectual property.
So another question on work for hire: if you outsource help to work on your designs, how does that fit into a work for hire situation? And they're asking if an NDA would be sufficient.
No, absolutely not. No, you need to have a written agreement regarding the creation of whatever it is they're creating. And again, since it probably doesn't fit into one of those 9 bizarre categories, you'd need to say that that I would own, I as the hiring party would own the copyright and physical manifestation of whatever it is you're creating for me. And further, you should say that if I choose to copyright it and I need to get something signed by you, you'd agree to sign it. So you have to make sure it's got, all that stuff.
Yeah, it's interesting because I didn't know that the work for hire idea was that had those 9 different criteria.
Yeah,
and so I've done that in my business. I've said, this is a work for hire, and I assumed that was sufficient if everybody agreed. But what you've told us is that it's not.
No,
that it has to fit into one of those 9 categories.
Right. That's why.
So
why
here's a question.
Well, what you have to have is in a work for hire agreement for something that isn't in those categories, like, for example, software, which bazillion people around the world are hiring bazillion people around the world to create for them. That is one thing that is not covered by work for hire and has to be specifically assigned in the development agreement.
So what you're saying there is that in a development agreement, whoever is doing the development, whoever you've outsourced this to, has to agree within the agreement that you own it.
Correct.
And they don't own it.
Correct.
You can potentially, so that isn't, so in other words, you can't rely on the work for hire. You cannot rely on your own internal designation of it as a work for hire to get anything for you. Yeah. Okay, so here's an interesting question. After
as if these other ones weren't.
Yeah. Well, this one goes into, if you get a trademark, how do you make sure that all the different states and territories and everyone don't have companies that come up with the same name? Is there a way other than creating a company, an LLC or an S corp or something in those countries, in those different states?
No, I mean, what you do, I mean, what is done before the trademark is filed, primarily because it takes so freaking long for the trademark office to process a trademark, like 18 months, is that you have to do what's called a trademark search. And there are services that do this. There are ways to go about doing this, where people check website names, business names, product names, all over the country. They know where to look. They know what databases capture that information. And that's the only way you can do it. I mean, forming a company name doesn't really protect you because it's not, it doesn't relate to a product or service necessarily.
Okay.
So the answer is trademark search. That's why I said, when I said that, the whole idea of protecting a trademark, the process of the protection makes sure to you that you are not
by using the trademark you want to use, that you're not infringing somebody who's already out there in the world.
So now that brings another kind of question here. So there's nothing to prevent someone that's going to start a company isn't going to do a trademark search on the name to see if it was somewhere else. I mean, the states will say, is there another company in this state that has that name? And if not, you know, then they can.
Right.
They can
Or is there another company from another state that is qualified to do business in that state using that name?
Right.
Which is the other way.
Yeah, but that company, so there's not, you know, there's not an easy way to prevent somebody from creating a company with the same name, but they can't get a trademark because you already have a trademark
Correct.
on the name. And
Correct.
if they are in a similar business, just like you said with United Fruit and United Airlines,
right?
If they're in a different, totally different business, then they could get a trademark on that because they're in a different business.
They're in a different business. Exactly right. It's all about the product and service classes. So all of this intellectual property stuff is unfortunately complicated.
Yeah. So here's a question: that does the design category cover something like a training curriculum, or is it more like blueprints or product?
Yeah, it's more like blueprints. It's more like the design of a product. What you mentioned is probably copyrightable. The specific training methodology.
Yeah. So you could copyright the training material,
right?
Is what you're saying,
right?
Yeah. Okay. And so there were a couple of questions relating to international stuff, and I responded to one saying you're not really covering international because that's a whole other.
Yeah, it is. I mean, I can tell you, I can give some basic, just overarching, comments about it. Copyrights start out in the United States. There are treaty relationships with other countries where if you have a copyright here, it's easier to get a copyright someplace else. Trademark is not like that at all. One of my partners had he was a trademark lawyer, and he had an entire Rolodex of people who were lawyers in, as he put it, every country in the world from Azerbaijan to Zanzibar. So if somebody wanted to trademark something someplace outside the United States, you have to hire outside counsel because there aren't necessarily treaties around all of trademark, and the same with patent. Yeah.
Okay, so we're getting close to the end here, to our 7 o'clock hour, and I hate to do this to you, Larry, but if people have questions or would like for you to do a mentoring session, you are available for mentoring.
I am a mentor.
To the to the North Chicago .score.org, and there's a find a mentor section, and you can find Larry. And please don't inundate him with things, but that's what he's there for. He's a retired lawyer, so he has some time.
I do, but the one thing you have to understand, one thing that you have to understand with regard to any retired professional who is a SCORE mentor, so that includes lawyers, accountants, anybody. We can't do work for you. In other words, I can't be your lawyer on any of the things I talked about in connection with intellectual property. I can't file a trademark application. I can't sue somebody for infringement. I can't even review a list of existing trademarks and tell you whether what you want to do does or doesn't, fit in the world of the possible. All I can do is try to elucidate some things for you and get you sources of information, and that's all any SCORE mentor can do. So, with that caveat, happy to help anybody.
Yeah, and I do mentoring with Larry, and I know he's an excellent mentor. So again, please, if you have any questions, you can get in touch with Larry. We are we have see if you can go to the next slide. I think we've got a couple of upcoming webinars here. One is on February 9th at 6:30 about how to increase sales without adding a salesperson. And then March 15th, we have Understanding Small Business Financial Reporting. And for those of you in small businesses, you know March 15th is a key date for filing your taxes for the companies. So that's very, very appropriate there. Let's see. So I think we would certainly thank everyone who has joined us this evening. And as a reminder, this recording is this session has been recorded and will eventually, in a week or so, end up in our YouTube channel on YouTube. So if you go to the SCORE website, northchicago.score.org, there is a YouTube logo in there, and just click on that, and that'll take you to our YouTube page. Where you can see not only this webinar, but I think about 9 or 10 other webinars that we have given on the last couple of years. So again, thanks everyone for attending. And Larry, thank you very much for doing the session here. It's greatly appreciated. And I know that we've had an incredible number of questions, and I'm sorry we can't get to all of them here, but hopefully we can, you can get some of these.
They may turn into SCORE sessions.
That they may turn into SCORE mentoring sessions, which is a good thing.
Yes, indeed.
Because that way you can do individual items here.
Right.
So we will take our leave now. And again, thanks to everyone for participating. And watch out for the next set of SCORE sessions, which we have. They are always interesting and enlightening. And so we bid everyone good evening.